Hello everyone, welcome to my channel and welcome to another video. It is an interesting day in court today as the cross-examination by defense for accused number 1 and number 2 proceeds with Sgt Mogane. And before he starts, he goes on to place on record that he would like to refer the witness to Exhibit EE, and it's the last part with regards to the issue of address. He then just asks the witness that if she can see that the information over there is of Muzi Sibia, and the witness confirms, and the address is confirmed as well. However, it doesn't say Tembisa, instead it says Temba. And then Mngomezulu asks her if that is supposed to be Tembisa. She says yes. And he asks if that's a typographic error. And she says no, but if you look closely, you can see that there is an S and an A and what have you. And then the judge then interrupts and he says, according to him, the whole address is wrong because it doesn't say Vusumuzi section, it just says Vusumuzi in Temba. And then Mngomezulu emphasizes that the gist of his question is with regards to the number and the fact that it could have been an error, that the one was left out in the address that was provided by the witness yesterday. Once they dealt with that issue, they went on to talk about the issue from Dobsonville, whereby the version of accused number 1 is that his cell phone was switched on and they were browsing through his phone book to find a number written Mkulu. The witness then denies this and says that the name came up on the 30th already from Kininda when he asked her to do follow-ups with regards to this investigation. The defense then says the version of the accused is that they contacted Mr. Magwaza, who is a traditional healer, and she says, nope, when I went to Dobsonville, I went for another issue. And then Mngomezulu then asks her, okay, if you went to Dobsonville, what were you doing there? And she says, I did mention the charges yesterday, and you said I was assassinating the accused character. So do you want me to repeat? He then says, okay, let me just ask this. Did you meet a Mr. Magwaza? She then agrees that she did, and they spoke to him, they interviewed him. They did find that he was Muzi's traditional healer. So the version of accused number 1 to say that they went to a Mr. Magwaza and those contacts were taken from his phone is slightly confirmed by the fact that the witness does admit to seeing a Mr. Magwaza and interviewing him. The defense then went back to the issue of his trousers being changed, or accused number 1's trousers being changed. The witness did say that the reason why he changed his trouser after his arrest was because this trouser was expensive and he didn't want the people in the prison or at the jail cells to steal his clothing item. However, the version of the accused was that the reason why they allowed him to go change his pants is because he had been assaulted so badly that he messed his pants and obviously needed to change. Another aspect with regards to changing of clothing is that he changed from these so-called Brentwood pants, and he wore a pair of jeans, and then he also changed from a pair of flip-flops and put on a pair of Cavelas. Now, if you know the brand Cavela, it's a very expensive brand. So Mngomezulu just pointed it out to the witness that he's finding it surprising that the accused wanted to change his pants because they were expensive, but yet changed from flip-flops and put on a pair of Cavelas, which are more expensive than the pants he was wearing. He then, Mngomezulu then questioned the witness with regards to the J50 warrant of arrest, and he asked the purpose of approaching accused number 1 on the day of his arrest. The witness says it was to execute the J50, and Mngomezulu then asked, after the execution, did you detain this accused or suspect in Tembisa as per the J50? And she says no. Mngomezulu then questions her on the provisions of the J50. She goes on to explain that a person should be detained. However, she saw this as an opportunity to investigate him on other cases. Mngomezulu then asked if she was the investigating officers in those matters, and she replies to say the dockets were investigated by her office, so she had prior knowledge of these cases. Mngomezulu then questions the fact that this case number 21703 of 2019 didn't require further investigation because it was not put on the court roll due to the fact that there were forensic evidence that needed to be tested, and once that was completed, he then says that it didn't require further investigation. She disagrees with the statements and says it did, and she did complete further investigation on this matter. Mngomezulu then questions the witness with regards to a J175, and if she's aware of what a J175 is. She says yes, and Mngomezulu then says this should have the date of a trial, and the witness says correct, and just after she says correct, the judge says no, it's not necessarily the appearance or the trial, the date of the trial, it's the date of the first appearance. And then Mngomezulu asks if she does have a J175 with regards to this case, and she says no. Mngomezulu says this is an essential document, and she says no, she doesn't have it, and she did not apply for one. Now Mngomezulu then says, you don't have a J175, you don't have a return of service, and the witness says, what for? It's her attitude for me. Anyway, the judge then interrupts, and Mngomezulu then just puts it on record that he wants to explain his knowledge of how this process should work. He says that a summons is issued, and the IO then takes its duty is to effect service and then to appear in court. If the person is not found, then they go back to court to show that they've not found this person, which was not done in this process. So he asked the witness what process was followed to get the J50 without the J175. Baloyi then stands and says it is the discretion of the prosecutor whether they want to fill out a J175. And the judge basically then gives us the procedure as to what happens when you ask for a J50. And Mngomezulu was upset by this because he says the court is answering for the witness. And when the judge disputes this, he says no, he's quoting the law. And Mngomezulu then just says, I'll leave this for argument because the court has already answered for this witness. Mngomezulu then puts it on record the assault that took place in both Tembisa and Vosloorus, and the witness denies any assault having taken place. And then once that is done, Mngomezulu then refers the witness to the 31st of May. The accused was booked back into a prison cell on the 31st of May, or booked back into the police station, on the 31st of May at 20:02 in the early hours of the morning, and was booked out again at 11 for the purpose of investigation. So Mngomezulu questions what investigations were being done on the day, and she says no, there were further investigations with regards to the drug case and other cases, including the current case. Mind you, he had made a confession the day before with regards to this very case. Then Mngomezulu asks if she was aware that the accused was once in Silverton police station, and she says she cannot dispute this because during this time we were faced with the COVID outbreak, and sometimes when they try to take accused people to the police stations, certain police stations would have COVID cases, therefore they would have to take them to different other police stations. Then Mngomezulu, before he concluded with regards to accused number 1, he then says that accused number 1 did request to be transferred to a prison cell because of assault, and the witness then agrees to this, and there is an exhibit 00, which basically gives an indication that the person did report an assault from the SAPS in Silverton and requested to be detained in prison. The witness then says after that sort of reports, she then went to make inquiries at the police station to find out who was assaulting, and nobody basically admitted to the assault, which is pretty much what is happening in court now. They then went on a tea break, and we will continue with what happened after tea. After the tea break, Mngomezulu then asked the witness with regards to a logbook, and she says yes, the logbook is available. He asked if she was recording everything. She says that is correct. Mngomezulu then makes it known that the copies were not made with regards to the logbook. However, the copies will be made during the lunch break, and he will then cross-examine based on those records. We then go on to the cross-examination with regards to accused number 2. They confirmed that Mogane was not available when accused got arrested. And then also the version of the accused is that Mogale had previously contacted the accused offering him a job. This was several days or weeks before he was arrested. The judge then questioned as to what work was offered, and Mngomezulu says it was not specified. They go into the details of the day that accused was sent for questioning in the boardroom, and the version of the accused is that Gininda was present when the accused was being questioned in the boardroom in Pretoria. However, Mogola denies this. She then says she arrived at the Pretoria boardroom or Pretoria police station, Pretoria North Police Station, after the questioning was done, so she wasn't present for any of the questioning of the accused. She confirms that she was driving a Golf 7, a white Golf 7 during the time, and she does not recall the registration. She then also confirms that she did drive with Gininda on the 18th when they took accused number 1 to confirm his employment. And then Mngomezulu leads the evidence with regards to the assault that took place on accused number 1, and the witness blatantly denies any assault happening. Mngomezulu then points it out to the witness that all the other witnesses that have come before her also had denied the assault. However, when the AVL records were presented in court, the tune changed. Mngomezulu continued to state out the accused version with regards to the assault and where and when it took place, and all of this was denied by the witness. They then questioned her with regards to the night of the 19th and also the 20th. She says yes, she was with the accused on the 19th because they traveled to Phokeng to look for a hoodie that he was apparently wearing in 2014. Mind you, this was all the way in 2020, 6 years later, and they were still looking for a hoodie at his place. She was questioned as to where she was coming from. She says she came from the offices in Ayrton, and then she also says that she did not see Jonathan, which is the EMPD officer, on that day when they traveled to Phokeng. Now we then go into the issue of being detained. And Mngomezulu basically questions the witness with regards to when a person has been detained, do you not take everything from the person? She confirms that this is the case. However, if you remember her evidence, she says that the accused's keys were taken from his pocket, which couldn't have been possible if the accused was detained on the 16th because all his belongings were taken. And the version of the accused is that his room was entered into forcefully without the keys. And Mogola denies this. And then also the ammunition issue, whereby they entered the room and they found ammunition in his room. The accused says, when I was taken to Phokeng, firstly, I was left in the car. The room was entered without my permission, and that ammunition was discovered without me being there. And then the judge basically butts in because Mgomezulu was cutting off the witness, and the judge says, let the witness speak, because she was about to tell us as to why the case for the possession of ammunition was the accused was acquitted. So she then went on to explain that the reason why the accused was acquitted was because when he was arrested, he was with his girlfriend, and the girlfriend was left at the house. So therefore the court ruled that the girlfriend was left in the house, so therefore it's not proven that the ammunition actually belonged to accused number 1. Now, one thing I will tell you about accused number 1, he's got an impeccable memory. He's a very intelligent guy, because he then raises his hand and calls Mgomezulu over to him, and he explains all the reason as to why he was acquitted from this case. And then Mgomezulu comes back from speaking to accused, and he then asks the witness, was that the only reason why he was acquitted? And she says, that's the only one I could recall. And then Mgomezulu goes on to say, well, these are the reasons that accused has given me as to why he was acquitted. The first one is the reason that you have given the court with regards to the girlfriend being in the house and left there for 2 days before they actually came back. The second reason is that there was no warrant to search the premises when you retrieved the ammunition. The third reason was that there was no warrant of arrest for the accused. And then the last reason was that when the court asked for the exhibit, which was the ammunition that was found, the exhibit was not brought before the court. Now, this is very interesting, because why would you not bring the ammunition to the court for it to be tested for DNA to prove that this person is responsible or owns this ammunition? Interesting times. So Mgomezulu was about to wrap up his cross-examination before lunch, when he then says he's wrapping up his cross-examination. However, he might still have a few questions with regards to the logbook. So he requests that we take the long adjournment for lunch so that he can browse through the logbooks, and then if he has any questions, then they will continue with cross-examination of the logbooks after the lunch break. Advocate Mnisi for defense for accused number 3 has indicated that he does have a few questions for the witness, so we are prepared to hear those questions from him. And also defense counsel for accused number 4 has also indicated that he also has a few questions, so it's clear that Sgt Mogane will still be here for quite some time. After lunch, Mgomezulu just had one question to the witness with regards to the 21st of June, if they did visit accused number 2 in Pukeng with Gininda and Mabena, and the witness says no. Advocate Mnisi for accused number 3 then took to cross-examine the witness, and he basically clarifies that he is not cross-examining. However, he just needs a few clarifications with regards to the evidence that was provided by the witness. He then just goes back to say, he realized that the witness does say that she read the rights to the accused maybe 3 or 4, maybe even 5 times, and the witness agrees. And then after that, he goes into the legitimacy of the process with regards to reading of rights. And he just asks the witness what happens if these rights are not read to the accused. And she then says that it becomes unlawful. And he asks when was the first time the rights of this accused was read in connection with case 636. And she says it was at Vusumuzi Hostel. This was done whilst the accused was in the car and she was outside the car. So she was reading these rights from the window. There was major debate with regards to what she did after reading the rights, because there is a right to an attorney, and if a person doesn't have an attorney, the state will provide one for them. However, they don't state, or the witness does not state, what option the accused took. And by this, then Mnisi says then there was irregularity with regards to how the rights were read. Nisi asked the witness at what point did she ask him what he chooses to do, and the witness starts by narrating basically a story. And Mnisi says he's not looking for a narrative of a story. He is aware of the tactic that she's trying to do. And Baloyi then objects and says she's giving a sequence of events, and the judge also intervenes and says they should stop trying to stop her from answering. They should just let her answer. Okay, Mnisi then requests that he moves closer to the witness as he's unable to hear her answers. And he then moves closer and continues with his line of questioning. Mnisi continues to grill on the point of the rights that were read and also the option that accused number one chose. And then after that, he went into an interview that he conducted that was before the accused started making admissions to her. And there's a form that he refers the witness to, which is SAP MM. And basically, this form says that every time an interview is conducted with the suspect, it needs to be filled out. And there's obviously an argument by the state to say this is only when a statement is taken. However, the form does clearly state that for every interview. And Mnisi then refers them to another paragraph in the form that says, it's an instruction to all investigating officers that this form needs to be completed every time they question a suspect, whether they are detained or not. So that was the gist of the question from Mnisi. And I saw Mngomezulu agreeing with this question by Mnisi, which was very interesting to see. And as Mnisi was completing his line of questioning, he says he puts it to the witness that her failure to comply with the instructions on the form was an irregularity, a fatal one at that. The judge, obviously with his 2 cents, then comes in to say the document that Mnisi is talking about is referring to an interview. And as Mnisi tries to explain, the judge stops him and he says, this is how I see it and I don't want to argue with you. Mnisi's line of questioning was over, and defense for accused number 4, Umalo, had no questions to the witness. Today, Advocate Mshololo was not available in court. However, she did have her colleague Munyeki, who was standing in for her, and he did say that he does have a few questions for clarity. He then goes on to say, you say you arrived in Phokeng and went where on the 19th of June? The witness says they went to the police station, and he questions if they found accused number 2, Mogane and Mabena at the police station. She agrees. And she says, you were then escorted to Ntanzi's place from there. She agrees. And he asks, are you 100% sure? She says yes. And then he refers her to a statement that she made previously that she will put her head on the block, and she says yes, that's right. And then he then goes on to say, Sgt Mogane says when they went to Phokeng, they didn't go to the police station, which is accurate. And she then says, but my testimony is that we met them at the police station, and her voice really sounds a bit shaky at this point. And then he also goes on to say Mogane didn't say that, and also the AVL that Mogane was leading also states that they didn't go to the police station, right? He then basically says that Mogane did produce an AVL which proves this version that they didn't go via the police station before going to Ntanzi's place. And then the judge interrupts him with the wrong information, mind you, because the judge then goes on to say, no, I listened to the record. You didn't listen to the record because Mogane had said every time they go into a new place or an area that they don't have authority in, they have to go to the police station and ask for an escort. And then Munyeki answers the judge and says, my judge, we can go to the record. I maintain what I said. Rightfully so, because Munyeki was right. When Mogane originally gave his evidence, he did say that they do go to the police station to request escort services, especially in an area that they're unfamiliar with. However, when the AVL records were then put to Mogane, his story changed and he said that they didn't go via the police station. Himself and Mabena drove straight to Ntanzi's place. The witness then says she maintains that they went to the police station and Mabena and Mogane were there. Then Munyeki says he will leave this for argument. He then says to the witness, I put it to you that if Mogane and the AVL are correct, then your testimony on what happened on that day can't be correct because you were not there. Then Baloyi objects and says, no, that's not what Mogane said. Mogane said they waited for Kininda and Mohola with the escort. So what the defense is putting to the witness is incorrect. And then the judge butts in yet again and says, because you believe you're correct, please continue. And then Munyeki says he'll leave it for argument and he has no further questions. Just before the court adjourned, the judge had a very interesting question with regards to the shoes that women officers wear. He says it's not a sexist question, but the witness then goes on to answer that they wear boots, or because she doesn't really wear uniform, she wears formal shoes in the office, but when she's out she wears tackies. So those were the proceedings for today, the 22nd of November. I will see you guys again tomorrow.